Welcome everyone. Today we'll be discussing on disciplinary procedures and control mechanism. So basically everything that needs to be understood as far as disciplinary actions are concerned, why particular disciplinary actions are initiated in the first place, the importance of documentations, the grievance handling procedures, and probably the steps in disciplinary process is what will be the premises of this particular discussion in today's video. We will be talk about the purpose, why the requirement of disciplinary action. It means to ensure or have a proper, fair, clear, useful tool for correcting, improving performance problems, as well as provide a process to assist management in handling instances of unacceptable personal conduct, as the case might be. This is what we are looking for it. Why? To provide a fair, clear, and probably a directive tools for correcting and improving performance. This is the very undercurrent of having any form of disciplinary measures in place. So the question is to correct, essentially improve performances or work behavior. Provide specific. If you look into the pic that I've given it to you, wherein a person has been actually listening and a person has been advising all together. So it's a corrections or improvement of behaviors and performances what we are looking into it. Giving pinpoint feedback, maintaining consistency in the work unit, documenting it, thereby just cause. Just causes are the insubordination. Now, what is insubordination? When probably subordinates do not listen to his or her bosses, right? As the directive which has been done. And when we say doesn't implement the actions or directions, works on the directions of the boss, you are looking at the just cause of having to look for indiscipline out there, and this methodology or this process is known as insubordination. When in you actually revolt passively or aggressively or basically do not cooperate with the directives that has been issued to you is what we call as insubordination. Unacceptable personal conduct, definitely yes, people don't misbehave, people probably do not keep themselves aligned with the professional ethics of the behavior of the corporate bodies, or for that matter, anything that the society entangles into it. Unsatisfactory job performances. This is what we the differences between the actual and the standards are too far and too wide in between. That is what we will call about unacceptable job performance. Gross inefficiency is another reasons where we look into the matters very diligently. So unresolved incidents is act of unacceptable personal conducts. Definitely yes. Unsatisfactory job performance, grossly inefficient job performance for which no disciplinary action has been previously been taken by the agencies, thereby which are basically stated as which will be detrimental not only to your co-workers but also to the properties and eventually the organization. So these are unresolved incidents, the acts of unacceptability, that absolutely unsatisfactory job performance, grossly inefficient performance by the agencies as the case might be. Insubordination, yes, the question says no. The pictograph which I've given it to you, willful failure or refusal to carry out reasonable orders from an authorized supervisor. And that is exactly what we are looking at it as far as insubordination is all about it. When you're not listening to your superiors and failing to give a heed to it. Examples of insubordination are receptionists is asked to assist a visitor or refuse because she does not like to be interrupted, as the case might be. Mechanic is asked to take a state car for a test drive to see what is wrong with it, refuses because it doesn't think it is necessary as such. I've given you an examples altogether. Definitely, as a reception, when there is a visitor into the premises of the organization, does not entertain the visitor in the first place, because why? Because she must be working something on her personal profile probably, or on her professional capacity, maybe handling a phone, handling a mail and things like that. But then she need to understand, or he needs to understand what is to be prioritized, and this is a glorifying example of insubordination, as the case might be, when just directive, absolutely whatever is required, you do not follow the orders. Unacceptable personal conduct, let us understand what is it. Conduct for which No reasonable person should expect to receive a prior warning. Absolutely, yes. Violation of the governmental rules, definitely, is unacceptable. Willful violation of known or uh, written work rules which has been explicitly stated. For example, you are supposed to wear a particular type of an attire and you come with a different sort altogether, as if you do not care for whatever has been mentioned or categorically stated by the organization. Falsification of employment documentation, conduct becoming unbecoming of a state employee that is detrimental to the state services, including criminal convictions, abuse of persons over whom the employees has charged, absence from work for leave and benefit is exhausted as on when on basis, as the case might be there. What we are looking forward to it is what is the requirement of the day. Example of unacceptable personal conduct, swearing it. Probably yes. You cannot use slangs. You cannot use abuses to any of the co-workers. Forget to your seniors. Falsification of employment or other documentation. Let's say the expenses records, your claims that comes around it. Any kind of misappropriations of documentation is absolutely not to be tolerated, or a zero tolerance policy has to be awarded against such kind of things. Convictions of a drug possessions with an intent to distribute, missing work without leave to cover the time period, as the case might be. This is what we are looking forward to it every now and then. And then comes the unsatisfactory job performance, work related to performance that fails to satisfy the job requirement as set out in the relevant job description. This is all about the work plan or directive as with the management of the work unit or the agencies thereby. We are looking forward toward it. We have these set standards altogether, and if you're not failing to meet that set standard, not once, not twice, not three, but repeatedly, how can you expect that organizations to sustain you? So without performance related work, if you do not actually attain that performances, that's a satisfactory standard, you things will be difficult, and that is where disciplinary action has to be initiated if required. Allow me to give me a unsatisfactory job performance. Let's say an excessive absenteeism, failure to complete assignment when they are due on time, and this is the most general causes of doing it. And repeatedly, when you do it, it is unsatisfactory job performance. Excessive errors in completed work, excessive callbacks on repairs, as after every work that you completed, there are complaints, there are faults which does creep upon it. Tardiness, lost file, equipment due to disorganization. Now, when I say talking about lost files or equipment, it cannot be tolerated n number of times, right? You have to be diligent, you have to be regular, you have to be punctual, you should be coordinated, you should be organized. In short, cross inefficient job performance, as the case might be. How do you go across it if you are not having a satisfactory job performance? Now, why does this below par performance appears? Because it might actually lead to death or a serious body harm, or create conditions that increase the chances for both of such kind of things to employees or other persons. Or second point is the loss of a damage of state property or the company's property funds that result in serious adverse impact on the state or the work unit, as the case might be. Example of grossly inefficient job performance: employee on a trip with the state vehicle drinks and has an accident. Employee leaves a bank deposit containing $10,000 in cash, probably on the sink of a restroom, and it is stolen. So you are misappropriating. Maybe you might not have done it on intention, but how can you be irresponsible? And that is what a grossly inefficient job performance is all about. It employee leaves live wire exposed with no warning sign. Posted, and other employees get severe burns from touching, as the case might be. The types of discipline is oral counseling session, not considered as a formal disciplinary action. Written warning actions, suspensions without pay, demotion, dismissal. These are the types which comes around it. People may be dismissed. Obviously, they might lose their employment. They might be demoted to a lower rung position, lower responsibility, lower pay. Suspension might be there without pay. Written warning and oral counseling is what the softer method goes around it. Disciplinary process, oral counseling. A recommended first response to unsatisfactory performances, supervisory conducts, counseling session, problem areas are identified and discussed. Improvement plans and time frame are discussed and noted by supervisor. Supervisor maintains a record of sessions, not considered part of the formal disciplinary process as the case might be, as we are looking forward to it. Let us understand the written warnings, wherein it has been given to you in black and white what is expected from your end and what is going wrong. It's a written statement of unresolved incidents of unsatisfactory performances thereby. Remember, written warnings are required when it is to be stated that things are being noted down. It is on a serious note. Specific conducts of performance has been noted down. Specific performance or conduct improvement has to be put in place. Indicate the time frame if not included. Defaults to 60 days for unacceptable job performance and immediately for grossly inefficient job performance or personal conduct as the case might be. We come into the written warning. Now, state consequences of failing to make required improvement and correction. Give appeal rights provided by agencies, policies, or state laws. If second written warning, it should encourage the use of employee assistance program or EAP. Now, what has been trying to tell it to you is wherein the employees are being given an opportunity, a window of options that goes comes has been open to them as to look into what has been expected and how they can improve upon their performances is what the written warning would be coming. The first written warning is to initiate the second written warning, if any, might encourage the person to take up the issues directly so that it should be resolved. And in case if it persists, it might lead to abnormal records and abnormal actions which may be completely detrimental to the employment. Now, written warning process, supervisor prepares a draft, forwards it to the ERM or the human resource managers or the employee relations manager. The ER managers reviews a draft and makes recommendation or correction if what has been done are probably iron out the languages. It cannot be looking very stern. Approves drafts are returned to the supervisor. Supervisors schedule the time to meet with an employee as the case might be. This is what we are looking. Employees and supervisor discuss the warning. Supervisor gives employee copy of warning. As the case might be, supervisors forwards the final written warning to the employee relations managers for inclusions of the employee disciplinary file kept separate from the personal file. Written warning remain active for approximately 1.5 years from the date of the warning, and if things goes wrong, if things do not improve within those 18 odd months, you might be penalized. Suspension without work is where the employee is not permitted to work for a definite period of time. It might be extended from 2 weeks to 2 months. Without receiving the pay, employees are not permitted to apply leave towards the suspension. Without pay, it might be 5 days, 10 days, but it might extend from 2 weeks to 2 months period. Demotion is another disciplinary action where an employee is subject to an action that lowers the salary within the current pay grade or is placed in a position as a lower pay grade with or without lowering the employee's salary involuntarily. That is what we are looking as an employees. Remember, employees are subjected to an action that lowers the salary within the current. Absolutely, it's demoted altogether, and it might look as a financial pay crunch, but it actually hits below the belt in the terms of the ego has been hurt, the principles has been hurt, the employee might feel insulted, and without the management or supervisor insulting, it might be the co-workers who might make fun of the person around there, and that is what demotion is all about. Another detrimental, or should I say vindictive, or should I say the most negative implications of disciplinary action is dismissal. It is basically involuntary termination of employment. Suspension without pay, demotion, and dismissal as how we go around it. This is the process wherein supervisors submits the memorandum to the employee relationship manager, documenting every cause that he or she fits is right for the action. The employee relationship managers determines if requested actions may be used to keep as a disciplinary action. The employment relation managers schedules a pre-disciplinary conference with an employee, giving advance notices and the reason for the conference to discuss the supervisor's recommendations. This is what we call as pre-disciplinary conferences. Advance notice occurs between employee relations, managers, employees. No side may be represented by the attorney. Remember, security may be present, may not be present. The conference is given an advance notice wherein things will be discussed. And why the security has been in place? Because if things flare up, they are required to make ensure that the things do not go beyond a particular circumstances, beyond a particular limits. So of course between the HR fellow, the employee relationship managers, and the employees, no side may represented by the attorney. Disciplinary conference. Employee is being given an oral and written notification of the employee recommendations around here. Employee is given an opportunity to respond to the recommendation and offer the fact supporting to another courses of action that comes around. This is what we are looking forward to it. As a course of action, suspensions without pay, demotions and dismissal. Decision is made after the beginning of the business day following the days of the employee conference. But the employee relations managers, as the case may be, remember decisions may have supervisor's approval, may not have the approval. Recommend a lesser action. Probably the employee relationship manager might recommend a lesser action than dismissal or demotion or a written warning or a suspension without pay or suspension with pay, whatever the recommendation that comes around it. And recommend may obviously enhance the recommendation to a much more severe action as the case might be. This is what we call the employees and the supervisors are notified in a written direction. Suspension without pay normally is either of a week or a two. Supervisor decides when the employee will be on suspension. Payroll is notified to reduce the pay. Absolutely, the HR managers will intimate the accounts department, the payroll executive to about the pay related affairs. Employees is expected to return to the work on the next business day following everything that comes around it. Documentation comes around it. How does it goes about everything that needs to be understood every now and then, documented in an employee's disciplinary file as the case might be. If you look into it, how do we go about it? That is what I speak about, the suspensions without pay as the case might be. I am talking with you regarding demotions, maybe with or without suggestions. It might be with the decrease in the pay scale, absolutely on the grading scale that comes around it, reflected in the employee's disciplinary files as the case might be, may affect salary decisions, in promotions, in reallocations, if it is done within 12 months of demotions as the case is just all about it. So what are we looking at it? Are we looking at dismissal or are we looking at the demotion part of it? How do we come across with it? This is what needs to be understood time and again as the case might be. Yeah, we need to be very sure what we are looking as such with the things. Now, what as we look forward to it? Who is this that we are looking? The dismissal is can be about 2 weeks notice that comes around as the case might be about here. How do we go across? When do we do it? 2 week notice is what has been limited as such. What are the factual things that comes around it? How do you go about it? What is the thing that represent every now and then as the passage might be talking about it? Where does it helps me? So 2 weeks in lieu of notice is a gross period that comes across this, is the last day that comes every now and then. So we are looking for 2 weeks notice. Last days of work is considered as a separation date every point of time. Now talking about unsatisfactory job performances, types of disciplinary actions, the prior accidents, uh, employee has warnings. They have the current unresolved incidents and unsatisfactory job performance, thereby the warning that has been required as of period. At least one prior activities warnings of the other activities disciplinary action that comes around it. At least two active warnings, two active disc actions, or one active warnings or the other disciplinary action that comes around it. So we have warning, we have suspension without pay, we have demotions, we have dismissal, as the case might be about the pre-disciplinary conferences as the requirement factor. So we need to factor in the job performance with it. The employees has about the warning, the suspension without pay, the demotions, the dismissal, and so on and so forth. With the passage of time, it happens and happens on a regular basis. Yes, what we are looking, if an employee has a warning, it is an unresolved, which we require to have a verbal kind of scenarios. But in case if it is more than one prior active warning or other active disciplinary issues, so we can go for suspensions without pay, as the case might be. When there are more issues with two things, this is needs to be understood what can be done. We can also think about the demotions part if required. But in case there's a pre-disciplinary conferences, if it is there, please let us have it in this required format is when the suspension without pay is concerned. When considers about demotion is again something which needs to be discussed around here. In cases of dismissal, we need to have would have formed the first unresolved incident, the second one or the third one which comes around it. We take it consecutively and let it forward all together. Let us have that unacceptable personal conduct of grossly inefficient job performances. Now, what happens when employee has a warning, which is basically an unresolved issue that comes around it? Probably yes. But when there are many other things, when there are prior incidents, there are approximately we might not go into the steps with a lot of serious consequences. We can seriously deliberate upon the suspension. In the previous one, which I've told you, is the incremental inefficient job performance that comes around it. Every now and then, dismissals and things like that. We look into it. Demotions happens, dismissals happens, and things around. So how do we come across as a process might be? So let us forward it time and again. In terms of cross disciplinary action, believe me, the first thing is the only warning letters, and rest it can be a suspension without pay, it can be a demotion, and it can be a dismissal at the drop of the hat. Let us understand the consideration of applying a job discipline, as the case might be, what we are looking out here. With the passage of time, how do we go about every now and then that comes around it, everything that needs to be taken around? This is what we are looking at today's case scenario, as the case might be, right? So decide upon it, and then probably you will come to understand what is the right thing and how do we go about doing it, or else we cannot eventually absolutely will not be able to work anything forwards towards it. Let's have the corrective things that comes around it. How do we go about the correcting employee performance? Is an individual private firms ask for explanation, focus on performance, not on the employees but on the performances. Now we are talking, never criticize the person. If you start criticizing the person, it becomes either vendetta kind of issue, or it is an ego thing that creeps around it. So opportunities to learn the correct way, review past work record prior to the talking about with an employees, checking policies, procedures related to the issues, look at a longish terms, not at the short term process, consistency, never ever apologize, and don't get emotional at the passage of time. So let us try to be a very practical, thorough person. Let us not be very emotionally entangled into it. Never be apologetic. Maintain the tone on a very nuanced, balanced fashion. Always look at a longer term objectives. Never focus on the individual, but do focus on the performance. Ask for the explanation, ask for the reasons, review the work benefit, and this will help the employees understand that from what position you are talking. This will also help the employees to analyze why a particular situation has been crept out, why this particular disciplinary action has been discussed around it. So check your policies, check your procedures, look for explanation, look at the past history before you come to a conclusion for the disciplinary action. With this, I would like to sign off. Thank you for watching this video.